The judge hinted a gag order may actually be necessary for Fani Willis. Tell us why and what would that and how would that happen?
Yeah, that's a really remarkable part of the ruling. It's sort of towards the end, and it's the B storyline, but it's important here. Now, this refers to the church speech that I think Paula referenced earlier. A few days after the defendants made this motion to disqualify Fani Willis, she went in public in a church with cameras rolling and essentially said that the reason that this motion had been brought was racism. And the judge says in his ruling that that was a legally inappropriate statement for the DA to make. He's absolutely right. A prosecutor cannot make inflammatory public statements about the defendants. They're the ones who have their rights at issue. And the judge basically said it may be necessary to put a gag order on the DA. And that tells you something. I mean, look, Fani Willis has made, in my view and in the judge's view, improper public statements throughout this case. She's given dozens of public interviews. She's given her opinion on Donald Trump's guilt before the grand jury even voted on this, which is improper. And so it's pretty rare, I don't think I've ever seen it before, where a judge has said, we may need to slap a gag order on the prosecutor. Prosecutors are supposed to operate under gag orders anyway. Prosecutors like to say we do our talking in court. Here, Fani Willis has violated that principle, and the judge has taken note of it.
The judge did call comments that Willis made in January at an Atlanta area church about the case legally improper. He said a gag order isn't the question before the court, but I wonder if you thought he was basically saying he might be inclined to grant one if he's asked to do so based on public comments she's made about the case.
What's really important to understand about that dynamic of the opinion is that we don't want DAs to ever, not even remotely, discuss the facts, innocence, or the allegations of wrongdoing in a substantive way in the public eye. And so we don't want to taint the jury pool. What Fani Willis did in her church speech was speak in very broad generalities. And that happens a lot because DAs in Georgia, and as is the case in many states, are partisanly elected officials. So they will make campaign speeches. They will make appearances in the public and talk about their philosophies generally. But what she did here for Judge McAfee was a step too far in impugning the character of the defense attorneys and perhaps coloring the view that people in Fulton County and the jury pool here would have of the case that's been brought against Donald Trump and his allies in an improper way. So I think she's been warned pretty significantly by Judge McAfee to not step out of bounds and to really only speak through legal filings.
In terms of affecting a jury pool, he seemed to say, or he said in this filing, that there's enough time between now, when this decision has come out, and when jury selection will begin, that it's not going to affect that. He says it shouldn't get in the way. But what if potential jury members have heard about this evidentiary hearing? Do you think that could be a factor in jury selection they may be asked about?
The voir dire process, which is the process which we screen potential jurors through, was going to be complicated no matter what, in large part because this case is so salient and so politically polarizing. It'll be very hard to find a panel of jurors who don't have some kind of preordained notion of what this case is about and who can judge the evidence fairly and impartially. That was always going to be an issue. But I think time is to the DA's benefit here and to everybody, the entire judicial system's benefit here, because people have a fairly short memory. And that's especially true in a year like 2024, where there will be so many political issues, so many trials that Donald Trump has in other places, that this may be just a blip in people's memories in the long term by the time we get to a trial, which may be very late 2024 or even early 2025 at this rate.
That's your expectation. She's pushing for August, but that's what you expect on timing?
There's a lot more that we have to go through, I think, before we can talk about an August trial. Two things are true. There are other important pretrial motions that are still under consideration by Judge McAfee, one of them being one about presidential immunity and the supremacy clause, which is related to a case that the Supreme Court will hear next month. So he may want to hear what the Supreme Court has to say about that before he weighs in, and that might take some time. And there are other sundry issues that have to be addressed. And the other important key dynamic here is Donald Trump can't be in multiple places at once. So if there are other criminal trials that are happening in the summer or early fall, then Fulton County will have to wait their turn. It's not impossible that we'll have a late summer trial perhaps, but I think at this point it's impractical.
All right, Professor, very interesting, especially there on the timing. We appreciate it. Professor Anthony Michael Kreis, thank you.
Let's discuss the case now with National Security Attorney Bradley Moss. Bradley, thank you so much for being with us. So Judge McAfee here is saying that there is no effective conflict of interest, that the relationship between Fani Willis and Nathan Wade was not relevant to the charges against Donald Trump and his co-defendants. But he does say that there was an appearance of impropriety that must be removed. What's your main takeaway from that ruling?
Yeah, Judge McAfee here, it was a pretty even-handed ruling. He basically decided, I'm not going to throw the baby out with the bathwater here. There was a bunch of smoke. There's certainly a stain on the reputation now of Nathan Wade and of Fani Willis and of this prosecution from an optics standpoint. But as a matter of law, in terms of the evidentiary standard that these defense lawyers had to meet, they simply didn't have the proof that there was an actual conflict of interest, that there was an actual financial material benefit tied to Fani Willis in prosecuting this case that would mandate disqualification. But he agreed with the idea that because there is this stain on the case, that because there's the appearance of impropriety, someone has to go. And that's almost certainly going to be Nathan Wade. The case will continue on. And the question becomes, if this gets to trial, will the voters even remember what happened leading up to it if it makes it to trial and we have a verdict before Election Day?
You said it'll almost certainly be that Fani Willis stays and hires a new lead prosecutor. How does that process complicate the case? It doesn't seem like this August timeline that we were trending toward is tenable.
Sure. So the idea is that she's most likely going to just rely on her existing team. She's indicated they're ready to go within 30 days. There's no way that's going to happen at this point, given the various changes in the schedule since that time, especially with the chaos we're seeing out in Manhattan right now with the district attorney's case in the Stormy Daniels matter. But it's more than likely that what Fani Willis will try to do is use the existing team that was already there. Aside from Nathan Wade, they can pick up the slack from that he would have otherwise handled, and they can still aim for an early fall trial. How we're going to figure out this trial schedule for a presidential candidate, given that almost all three of the other cases are certainly going to start no earlier than June or July, is something that no one really knows yet, and the judges have got to be just gnashing their teeth over right now.
Yeah, it is quite possible she doesn't hire anyone else and just sticks with the team that's in place. I do want to ask you about the potential for a gag order, because it's something that Judge McAfee alluded to. He described comments that were made by Willis at an Atlanta area church in January as legally improper. I want to listen to some of those remarks now.
I hired one white man, brilliant, my friend, and a great lawyer. And I hired one black man, another superstar, a great friend, and a great lawyer. First thing they say, oh, she gonna play the race card now.
In defending Nathan Wade there, the defense argued that Willis was tainting a jury pool. McAfee saying that it's probably too soon, we're too far out from jury selection for that to be the case. But he did say that the time may have arrived for an order preventing Willis from further discussing the case in public. Do you think that is essentially winking at the defense, saying that they should file a motion to impose a gag order on Willis?
I think it certainly was suggesting that they should consider it. Doesn't mean he'll necessarily grant it. We'd have to see what the scope of any gag order would be. But if I'm Fani Willis, I want to retreat from the limelight of this case right now, in the sense that let your line prosecutors, let the team you assembled be the face of this case. You're the political face, understandably. You were elected. You're going to always be the face in some manner, but let your team handle the case, prosecute it, bring it to trial, and get a conviction. You want to be in the background as much as possible, so that when people think about this case going forward, when they see it possibly going to trial in the lead up to Election Day, they're thinking about the evidence in the case, and they're thinking about the allegations against Donald Trump. They're not thinking about Fani Willis.
Bradley Moss, appreciate the analysis. Thanks for joining us.